ICE mandatory detention policy under Section 235, their interpretation has changed. Basically, the acting ICE director, Todd Lyons, sent a memo to his deputies for ICE this past week, and in that memo, he basically changed the interpretation that he previously had, that basically the government had previously had about Section 235 of the Immigration and Nationality Act. Now ICE is claiming that anyone who has entered the United States without being officially admitted, so they came in on a tourist visa or an F1 or some other valid status, even if those people came in years ago, maybe they came in across the border undetected and they later filed for asylum, basically anyone who came in entry without inspection would be considered not eligible for immigration bond. They would be mandatory detention, and these people are automatically detained and cannot ask for an immigration bond from the judge. Basically, the only way these people could get out of detention after they're detained by ICE would be if ICE granted them a parole. So if ICE on their own discretion under 212D5 decides to let someone out of parole, which by the way, that has not happened since Trump took office. As far as I know, no one has got out on ICE parole, maybe a handful of people, but as I've asked my colleagues, nobody has got parole. So if we're waiting on ICE to do it, it's not going to happen. Before this change, if you were arrested by ICE and you didn't have a recent border entry or a criminal conviction, maybe you didn't come through the water or some irregular way that they were otherwise considering to be an arriving alien inside the United States, these people qualified for an immigration judge to give them a bond. So all they had to prove was they were not a flight risk or a danger to society, and that they had some kind of fighting argument, a defense to immigration court, that they have some sort of immigration defense, and then they're not a flight risk. Those people were able to get out on bond in Section 240 proceedings. But now the government is interpreting that these people should be under Section 235B, which is mandatory detention. Only ICE could release these people. Now, this is most likely closely related to the $75 billion ICE budget that has just been approved under the Big Beautiful Bill, which expanded detention capacity to over 100,000 beds, and it gave $75 billion to ICE for things just like this. So what can we expect? Basically, if you have anyone who your family member came in unlawfully, maybe they filed an asylum, maybe they've just been undocumented and you filed an I-130 and you're planning to do an I-601A, these sorts of people, which previously would have always qualified for bond, are not going to necessarily qualify for bond. Now, I will say that immigration lawyers are fighting this, and that at least some immigration judges are pushing back against ICE's interpretation of the law and saying that this should only apply even if they're trying to say that EWI entries are not eligible for bond, that this should only apply to those who have come in the last 2 years. But we will definitely keep you updated on this change.